Many couples, both married and unmarried, own their property jointly. Depending on the way in which this property ownership is arranged, this may fall into one of two categories, either a joint tenancy or a tenancy in common. Determining which of these categories you may fall into if your partner passes away makes all the difference in knowing what to do next. With a tenancy in common, each tenant owns an individual share of the property. This is often expressed on the certificates of title in numerical terms to show the different percentages of ownership. For example, one person in a relationship may have 60 shares of the property with the other only 40. When one person passes away, their proportionate interest in the property can be left to another person or otherwise form part of their estate. However, if a tenant in common passes away without a will, the rules of intestacy apply. In most cases, the tenants in common are in a relationship which is recognised by the courts. As such, in most cases, the surviving partner of an intestate will inherit the whole of the property. This process, however, does not occur automatically and will require either an appointed administrator or the deceased next of kin to lodge an application to obtain letters of administration to deal with that part of the property. With a joint tenancy, two people together own the whole property. If one joint tenant dies, the surviving joint tenant will take ownership of the whole of the property. So, in effect, when a joint tenant dies, his or her interest in the property is transferred to the surviving tenant. Although this transfer is well established in the law, it's not an automatic process. In Australia, in all but extremely rare cases, a title held by the relevant state or territory titles office will be considered the best and clearest claim to a property. Therefore, despite the immediate effect of transfer when one joint tenant passes away, it's crucial that the surviving joint tenant take the necessary steps to amend their certificate of title. This is done through a survivorship application. Compared to the letters of administration for tenants in common, a survivorship application is a relatively inexpensive and simple task that requires only 4 things: an application by the surviving proprietor of the property, the certificate of title, a statutory declaration by the person making the application which details how they became aware of the death of the proprietor, and evidence of the applicant's identity. While the fees vary in Australia's different states and territories, this application should cost no more than a few $100s. Where there is a mortgage on the title, the bank may sometimes charge an additional fee for a temporary release of a title in order to effect the changes and have the new ownership registered. Naturally, the death of a loved one, particularly a partner, can be an emotionally taxing time, and any estate professional will be more than capable and willing to perform these tasks for you if you're unable to do so yourself.